Welcome, everybody, to this webinar. Thank you for joining us for today's webinar on the African Court Climate Advisory Opinion and the Case for Climate Reparations. My name is Patrick Toussaint from the African Futures Lab, and I'll be moderating today's discussion. This conversation comes at a particularly important moment. In May last year, a coalition of African civil society organizations, including the African Climate Platform, Natural Justice, Resilient 40, the Environmental Lawyers Collective for Africa, and the Pan-African Lawyers Union, formally requested an advisory opinion from the African Court on Human and People's Rights on states' obligations in relation to the climate crisis. If successful, this would be the first ruling within the African human rights system to directly address the climate crisis and related state obligations, corporate accountability, and possibly reparations for climate harm. This request builds on a rapidly evolving body of international jurisprudence over the past year, including advisory opinions from the International Tribunal on the Law of the Sea in 2024, the Inter-American Court of Human Rights last year, and the July advisory opinion from the International Court of Justice. These opinions together clarified that states have very concrete obligations to prevent harm, to regulate private actors, including fossil fuel companies, and to provide reparation where harm occurs. So the timing of our gathering today is very, very important because this is just after the submission of amicus briefs, so written submissions to the court, has closed in this advisory opinion process. This also comes at a time when African legal and political institutions are increasingly engaging questions of climate justice, responsibility, and reparations. In a way, it's also a continuation of a webinar that we hosted last year at the African Futures Lab and with AU ECOSOC, looking at what the ICJ advisory opinion means for Africa and for broader struggles around accountability and climate harm. Today's webinar is organized by the African Futures Lab together with our partners, the Center for International Environmental Law, the African Climate Platform, and the Global Climate Legal Defense. This webinar is convened under the Human Rights and Climate Change Working Group, especially the Reparations workstream, which has been engaging with these questions across litigation, advocacy, movement building, and political spaces. We are joined today by a really strong group of speakers, bringing together perspectives from African regional institutions, strategic climate litigation, human rights advocacy, community justice work, and climate science. We're very pleased to be joined by Mr. Lebogang Maboto from the political leadership of the African Union's Economic, Social, and Cultural Council, AU ECOSOC. We are also delighted to have with us Alfred Brownell, lead campaigner for the African Climate Platform and founder of Global Climate Legal Defense, as well as a globally recognized environmental and human rights defender with decades of experience supporting frontline communities. Next, we have the one and only Nchiko Anchiko. Nchiko is Regional Climate Justice Advisor for East and Southern Africa at Amnesty International and has worked extensively on climate justice, human rights, and accountability in African and international policy spaces. Particularly, I'm very fond of your work around decolonization and climate colonialism. From the Center of International Environmental Law, we are joined by the wonderful Joy Chowdhury, Senior Attorney in Ciel's Climate and Energy Program, who has been deeply involved in international climate litigation, legal advocacy around state obligations, corporate accountability, and reparations, and has led the work on the amicus brief to the African Court that our lab has had the pleasure to contribute to. And finally, we have the excellent Dr. Joyce Kimutai, who joins us from Imperial College London, where she's a climate scientist, specializing in extreme weather attribution and the evidence base linking climate impacts to responsibility and harm. To those who know her work, she's also passionate about Pan-Africanism and decoloniality, and she leads the African Climate Compensation Lab, which I hope she will tell us a little bit more about. Before we start, some quick housekeeping. With kind thanks to Ciel, we have a French interpretation available. please see the chat for how to access the French channel. We encourage you to put all your questions that you may have that arise during the conversation in writing into the Q&A chat box throughout the session, and we aim to leave some time towards the end of the webinar to answer some of your written questions. With that, let me hand over to Mr. Maboto for very brief introductory remarks. And I would also encourage all of our panelists to please turn on your cameras. Thank you.
Thank you very much, Patrick, and greetings to everyone who has joined. Distinguished participants and dear colleagues, on behalf of the African Union Economic, Social and Cultural Council, the AU ECOSOC, kindly allow me to begin by thanking the African Futures Lab for convening this webinar. That we gather here today before the court begins its deliberations is an indication that Africa's civil society understands the stakes of this moment and is determined to influence it. We also meet at a time when the reparations agenda has acquired unprecedented continental and global momentum. We note and commend the recent political momentum that has been building on the continent of the reparations movement, including the African Union's theme of the year and the decade. The first African Reparations Festival that was also recently held in 2025 under the theme Wakati Wetu, or as it was called rather, Wakati Wetu, meaning our time. And we see also this webinar as a good platform, as well as a good gathering that can help us perhaps reflect on the advisory opinion processes as a potential strategic milestone, and on strategic milestone on climate reparations on the road to COP32 and beyond. We have seen over the past decades, African member states, civil society, and diaspora movements having labored, and often without recognition, to change the global narrative on reparations from a fringe demand into the center of international political debate. Today, we believe that that work is bearing fruit. In 2025, the AU's theme, Justice for Africans and the People of African Descent through Reparations, catalyzed a wave of commitment across the continent, among global partners and throughout the diaspora. It was a defining year, especially in that it set in motion with the AU Executive Council declaring 2026 to 2036 the decade of reparations, aligned with the UN's second international decade for the people of African descent. Consequently, a convention that once had to fight for space in international fora now has institutional machinery and is treated as a matter of justice and accountability. The multilateral system is also beginning to respond. The UNGA recently adopted a milestone resolution by a vote of 123 to 3, declaring the trafficking of enslaved Africans the gravest crime against humanity and affirming reparations as part of the remedy. Importantly, it reinforces the view that the long arc of colonial extraction cannot be divorced from contemporary questions of reparatory obligation. 30 years after the Abuja Proclamation, through Durban, through the Accra Declaration, and through the advocacy of African civil society, the political tide is turning. Dear colleagues and distinguished participants, today the reparations agenda is the position of the global majority, and it's in the context. It's in this context that the advisory opinion process before the African Court on Human and People's Rights takes on its significance. The call for reparations is a call to restructure the future politically, economically, environmentally, and morally. It asks that the world we are building does not replicate the injustices we are trying to repair. ECOSOC has therefore played a catalytic role in insisting that the reparations conversation belongs to everyone it concerns. Through consultations, policy dialogue, and citizen-led engagements under the 2025 uh, autoplay, we have sought to democratize the reparations discourse, to move it out of the elite negotiating spaces and into the hands of youth, academics, creatives, diaspora communities, and the citizens whose lives remain evidence of why reparations are owed. In October of 2025, ECOSOC joined as a core organizing partner of the Wakati Wetu, as I mentioned in the opening remarks, Africa's first reparation festival held in Nairobi. This was a cultural reset that took the reparations debate into the public sphere and specifically into the hands of artists, activists, youth, feminists, and climate justice advocates. The festival demonstrated the importance of storytelling, memory, archives, art, and intergenerational dialogue as tools for healing, truth-telling, and reclaiming African agency within the global historical narrative. The resulting manifesto now stands as an important contribution toward building a shared Africa and diaspora consciousness and around reparative justice and political action. We must also be lucid about what these recent wins mean for climate justice. For Africa, the climate question is inseparable from the reparations question. Consider the paradox of our continent. Africa contributes less than 4% of cumulative global greenhouse gas emissions, yet 17 of the world's 20 most climate vulnerable countries are African. This disparity is the consequence of centuries of colonial extraction that depleted African labor, land, and ecological resource to fuel the industrialization of the global north, generating the historical emissions that now destabilize the climate. In this regard, the UNGA resolution is significant for the climate reparations agenda in many ways because it strengthens the argument that the systems that extracted African bodies, land, and resources also produce the carbon-intensive global economy, whose consequences Africa is now being asked to absorb alone. It reiterates that what many have long argued, that enslavement and colonialism hollowed out Africa's capacity for self-determination and development, and it locked the continent into export-dependent, resource-extractive economies, uh, structures that persist to this day and set in motion ecological disruptions through deforestation, land dispossession, and the erosion of indigenous resource governance that continue to compound Africa's climate vulnerability. When we center reparations within international law and supported by 123 member states, the resolution gives the climate reparations claims with something long denied to them, multilateral political legitimacy. As a result, it becomes increasingly difficult to dismiss these claims as grievances of a few. When 123 member states have now formally acknowledged the harm, that the harm was real, the obligation is live, the remedy is overdue. Accordingly, the AU Decade on Reparations now creates institutional space for African states to advance a common continental position on climate reparations. At the same time, the ICJ advisory opinion, unanimous across all 15 judges, gives that position the requisite force. Together, these developments are forcing the international community to confront the connections between historical extraction, carbon inequality, and contemporary patterns of vulnerability across Africa and the global south. This is reinforced by the AU's 2026 TOTY on water and sanitation. The choice of this theme shows that the AU understands that climate change is an environmental challenge, a governance and development deficit, as well as a public health crisis and a matter of human dignity. This is why the climate reparations discourse is important, because a continent forced to divert scarce resources toward responding to crisis it did not create is a continent whose development continues to be shaped by historical injustice. Over the past year, ECOSOC has worked to ensure that these realities are present in the rooms where decisions are made. Through the inaugural ECOSOC thematic working group on climate change, our engagement at COP30 and youth dialogues that brought the next generation's voices into policy discussions, we have sought to contribute knowledge, strengthen civic engagement, and advance the climate justice discourse from an African perspective. As we
Uh,
prepare for
May I
COP31,
kindly ask you to
yes,
conclude? Thank you.
yes. So, as we prepare for COP31 in Turkey, and with the eyes already fixed on COP32, we will be hosted in Africa under the presidency of, which will be hosted in Africa under the presidency of Ethiopia. Africa must enter at each of these negotiating platforms asserting its right under international law and demanding reparative justice. As I conclude, it is important to reiterate that the reparations agenda remains incomplete as long as climate justice is treated as a separate conversation. In this regard, ECOSOC remains committed to supporting and amplifying this process through its civil society networks, continental convening power, and engagement across the diaspora. I thank you very much and wish you fruitful deliberations.
Thank you so much, Mr. Maboto, for these kind words, provoking words. And of course, we're very happy to count ECOSOC as a key actor in the struggle for African reparative justice in the context of the climate crisis. Thank you also for bringing in the Wakati Wetu Festival, which we're very pleased to co-organize with you. And next up, we have Nchiko and Chico for a short and brief, and I am hoping very critical impulse to really fire up our discussion. Please, Nchiko, the floor is yours.
Yeah, thank you very much, Patrick. Thank you, Lebo, also for providing such a broader context within which we are to appreciate the advisory opinion request that has been presented to the African Court. Yeah, and beyond looking at the momentum that we've been able to register with all the advisory opinions that we are seeing coming up around the world, the wins that we are registering on the continent as Labour did put out. It is also very important to place this advisory opinion request within the context of climate change governance on the continent, the way climate change governance is happening currently on the continent. And it is happening in a very fragmented way. Yeah, for example, when we look at the Africa Group of Negotiators, which is the continental body that negotiates for all of us in multilateral processes, such as the UNFCCC COPs, when we look at the common positions that it present on behalf of the continent, we start to have an idea of just how fragmented climate change governance is on the continent. How does this work practically? So, for example, each November, December, at each COP, the Africa Group of Negotiators initiate a draft of common positions that will be presented at the next COP. So that is, for example, at the COP last year in Brazil. And then these drafts are sent to member states, particularly ministries of environment, which are going to work on them, make their contributions, and then send them back to the Africa Group of Negotiators. Such that when the group meets in June, like at the Bonn meeting in Germany in June this year, which is to prepare for the COP, they finalize the draft, and that's what we present on behalf of the continent. But really missing in these processes are the voices of civil society organizations and really other African Union organs, such as the African Commission on Human and People's Rights, the Africa Committee of Experts on the Right and Welfare of the Child, that have equally been doing commendable work in terms of the thinking, in terms of coming up with effective ways, effective proposals that can help us tackle the climate emergency on the continent, the climate crisis on the continent. And so really beyond looking forward to the findings of the court, which we should all do, how they're going to be complied with, how they're going to be implemented, it is also very important to just appreciate the advisory request in and of itself as this coordination device that is bringing all of us, like those of us on this call, together to raise or amplify issues that are really key to us and mobilize supporters around those issues. And the issue of reparations, of course, I think is the biggest of them all. And it's very critical that we are having this conversation at this particular point in time. And we can look at it in many ways. We can look at the direct impact of climate change, of global warming, of greenhouse gas emissions. Yeah, in terms of the cyclones, the floods, the droughts that are destroying livelihoods on the continent and displacing many individuals and communities. We can look at it from that angle. But I think Labour is really critical in putting this out. We can also it can be more useful to appreciate these issues in their historical context. So when we look at the peak of the Industrial Revolution, which is the main driver of climate change, that was also the peak of colonization on the continent. And then colonization was mostly about land policies that degrade the environment, water management policies that are not very sustainable. And the result of these wrongful acts today is to render communities, individuals around the continent more and more vulnerable to climate change impact. Maybe just a quick example as I conclude. Amnesty International released a report in July last year looking at the Antandroy people. This is a people, an agro-pastoralist community in the southern part of Madagascar. And this region of Madagascar has always known chronic droughts, even before colonization. But even as there were chronic droughts within this particular region, there was also at the same time a drought-resilient vegetation that could allow the Antandroy people to coexist with the drought whenever it was a drought period. So there was this ecological balance between the droughts that are there, but then there is also a drought resilient vegetation that could provide you with water, could feed you and feed your livestock. And they could sustain their livelihoods because of that. And now then came colonization. So the French arrived in Madagascar and they struggled for about 10 years to completely annex Madagascar because it was very difficult to colonize the Android region because the people are self-reliant, attached to their land, self-reliant on this particular vegetation. So they didn't really need to give themselves up into the cheap labor economy that the colonial administration was creating. And then beyond simply serving as a natural stronghold that could give people food, water, and all that, it was also a spiny vegetation. So it was very hard for the French colonial military to penetrate this particular vegetation. So what did the French administration do? What they did was to genetically manipulate certain parasites, put them in canisters, and then spray those over the vegetation, which was about 40,000 hectares of land. And within 5 years, all the land was down. But then remember, this is a people very much attached to their land. So whenever it's a drought period, a drought season, they leave and then they come back. Now, climate change came and the droughts are no longer periodical, chronicle. They're becoming more and more permanent. So in this context, it's very much, it's difficult to speak of climate change reparations without appreciating the question of colonial reparations. And this is just one of the many examples that we are seeing on the continent. I think I can stop there and give it back to Mr. Chair. Thank you.
Thank you so much, Nchiko. Really appreciate it, the way you tied in also some very concrete examples. You mentioned a report. Maybe you can drop a link in the chat. That would probably be cool for our participants. Thank you. So I think we're off to a strong start. Such important, provocative perspectives. And I like how you're tying in the political, but also essentially the question of colonial reparations as tied to this question of climate and reparative justice. Now, to open it up more to our broader panel, let's start with Alfred. Alfred, you were directly involved in bringing this request for an advisory opinion forward before the African Court. What concrete gap is this advisory opinion trying to fill that existing climate or human rights processes have not addressed?
Patrick, thank you so much, and thank to all of those who have joined us for this process. Yeah, we appreciate you. And this is the question that I've been asked over and over. I'm sure you will know since May of 2025, we've been really asked this question from the African Climate Platform. So just short intro, I'm the lead campaigner of the African Climate Platform and then also the founding president of the Global Climate League of Defense, which provide legal support for climate activists who are facing reprisals across the world because of their effort to try to phase out or dismantle the fossil fuel infrastructure across the globe. We've been involved in this work for the African Climate Platform for the last 4.5 years now. But this question has come more and more about, okay, what are the gaps you're going to address? There's the ICJ opinion, there is the Inter-American Court opinion, there's the Love the Sea Tribunal opinion. Why are you still going to the African court to address this? Isn't it very clear that the courts, the different courts and the regional system have laid out very clear jurisprudence to be able to guide you? Why are you pursuing this? So the first thing I would say is that our petition before the court seeks to clarify the obligations of African states under the African Charter. That is very, very clear. And I will provide a little bit more illumination upon that. But first and foremost, as we have heard from the last two speakers, what is very critical in terms of the gap that we see that has not been addressed by the Inter-American system, that has not been addressed by the ICJ, that has not been addressed by the Law of the Sea Tribunal, are some of the things that the first two speakers have focused on. The whole question of the colonial and historical responsibilities. The petition that will file call upon the court to recognize climate change has an ongoing consequences of colonialism, thereby integrating African reparation agenda within the climate justice framework. It underscores historical context of resource extractions, environmental degradation, and social economic exploitation that continue to impact the nation. As you heard the last speaker just say, of the sort of real serious, egregious violation of what folks in Madagascar are facing. And then our petition focuses bring an Afrocentric lens to address and respond to the specific human rights obligations, which I said earlier on. A focus on the article on African Charter, specifically Article 24, which uniquely guarantees the right to a general, satisfactory environment favorable to development, and a firm obligation to prevent, mitigate, and remedy environmental degradations. But in addition to Article 24, a petition lifts the issues around Article 4, which is the right to life, Article 16, the right to health, which invoke to address health crisis stemming from the climate crisis, Article 12, freedom of movement and residence. As we all know, one of the images across the globe is African trekking across the Sahara and crossing over the Mediterranean Sea, which apply to climate-induced displacement and migrations. And Article 60 and 61, which is used to interpret the Charter in harmony with other international obligations. But the specific Afrocentric issues in the African context, the petition highlights African issues, including food security, displacement, environmental and social impact of the extractive industries. And it's very clear if you know what's happening in the DRC and other countries across Africa, we're all talking about. Then it goes on to talk about vulnerable populations, the protection of indigenous people, women, children, human rights defenders. It also focuses on the issue of corporate accountability and third parties that have not been fully addressed in those other petitions. It demands the formulation of binding guidelines for states to regulate private actors, including fossil fuel corporations, operating within the African jurisdictions. And it highlights the need for holding corporations accountable for their contribution to climate-related harms. It raises the issue of the accountability of historical emitters. It requests that it could provide detailed guidance on the accountability and responsibility of historical emitters, particularly regarding transboundary harm to African countries caused by activities of high emission. In that regard, it references a distinctive angle by emphasizing issues of historical responsibilities and climate justice by critically examining that the 1.5-degree target is inadequate for Africa. It draws upon the whole question of just transition, especially in relationship to Africa, because it emphasizes African state obligations to implement comprehensive adaptation and resilience measures, prioritizing adaptation strategies over mitigations. And then an innovative legal doctrine, the whole question of a multi-generational responsibilities that I request the court to opine on. The idea of intemporal, which means that it advocates for recognizing obligations that protect the past, the present, and the future generations. This is the first time such a doctrine has been introduced, that the court will have to address those issues of recognizing obligations that protect both present and future generations, but including safeguards for ancestral rights of indigenous and historically marginalized communities across Africa. So when you ask for this gap, whether it's a multi-generational responsibility, it's just transitions, is for historical measures, for corporate accountability, for protecting vulnerable population, and Afrocentric lens focusing on the African Charter, but then the colonial and historical responsibilities. This is exactly why we've gone to our court, and we believe that it is the African court can adequately address this issue other than any other court. Thank you.
Thanks so much, Alfred. And I think you touched upon a little bit also the different opinions from the other courts. So in my head, I have a question to you, Joy. Obviously, you've been involved in different climate litigation at different levels. You're fully aware of what's been going on in the ecosystem. So it seems that there is real convergence in climate litigation on reparations. But where would you say are some of the key fault lines that you see that could shape the court's reasoning in this specific African proceeding?
Thank you, Patrick, and very much agree with the panelists so far. To take us for a moment back to first principles, right? You said that there's real convergence, and fundamental to law's ability, to the extent that it is able to deliver justice, the principle of ubi ius ibi remedium, when there is a right, there must be a remedy, has always been central to that landscape. So climate reparations should have been a given, right? But it isn't. So what we have seen in courts over several years has just been every argument under the sun, one more unjust than the other, thrown at climate reparations by major polluters. From let's all be friends and let's move forward together. Let's not look at the past, because looking at the past would be divisive. Or do human rights treaties actually say the word climate? And if they don't, do they apply? Or the science is so uncertain. Why are we even going there? And that was a fight. That has been a fight. And that is where we're starting to see real convergence, that courts are increasingly sweeping these arguments aside and making one thing very clear, that when there is climate harm, there is right to remedy and repair. That piece of it, which seems like it should have been self-evident, was very hard fought. And that is where we're seeing real convergence around courts affirming that the Paris Agreement does not displace broader principles of international law relevant to remedy, that responsibility does not disappear simply because there are multiple contributors, that states, and importantly, corporations, can be held accountable for both economic but also non-economic harms. Some of the worst harms that are experienced are not easily measurable harms to culture, to identity, to indigenous knowledge systems, to ways of life. And we're also seeing convergence around the idea that reparations is not just limited to compensation, but include varied forms of restorative justice. So, Patrick, what you mentioned, what are the key fault lines where this African court can really contribute in a way that would be essentially important for the reparations landscape? And I cannot agree with Alfred more that we are really looking to the court to fill some of those gaps. I think Lebo and Chico and Alfred, they all spoke about colonial harms and colonial legacies and reckoning with that deep climate injustice, reckoning with historical responsibility, including recognition that states are not situated equally with respect to responsibility for climate harm. Historical responsibility looks very different once colonialism is taken into account. And Ntiko's report is so important because it shows us that colonial extraction and dispossession continue to shape present day exposure and vulnerability to climate impacts across Africa and in many different regions. And this matters legally, not just for understanding harm, but for determining the content of state obligations, including reparations. And so the court can clarify further, what does this mean for the accountability landscape, including in relation to the principles of equity and common but differentiated responsibilities. And then the two other things, and there are many, but the two I'd mention is forms of reparation. Traditional forms of remedy are important, but they may not get us to climate justice outcomes. As affirmed by the Inter-American Court of Human Rights in its climate advisory opinion, states cannot meet their climate obligations without addressing the structural conditions that give rise to an entrenched climate harm, structural inequalities, extractive development models, territorial exclusion. And what the court could do is shed more light on such forms of reparations and what they might entail. And then the last thing, which I'll mention very briefly, because we have Joyce here and she is the expert, is on questions of evidentiary standards. International law has often required this causal link between the wrongful conduct and the harm experienced, and attribution science is advancing, but the burden of proving causation cannot become a barrier to justice, especially for the most marginalized, especially where the data needed may not exist or be easily accessed. And the Inter-American Court has given some compelling guidance on this, but the African Court now has an opportunity to further move the law forward in ways that are principled, grounded in justice, and responsive to lived realities on the continent. So I'll hand it back over to you, Patrick.
Thank you, Joy. Let me pick you up on that last point around the evidence and attribution. We have Joyce with us. You're a climate scientist. I'm very keen to hear your perspective on this. How do scientific evidence, but also litigation strategies that I think Joy alluded to, currently interact in advancing climate reparations?
Thank you. Thank you very much, Patrick. I hope you can hear me well. Good. I just also really want to thank everyone who's joined us today on this very important conversation, and also would like to thank the panelists here. I've really enjoyed your perspectives, your comments. Really, thank you very much for joining and contributing to this discussion. And to me, really, as a Pan-African, I think these are the conversations that we need to have more in our continent, to really talk about what is unique about our continent and how do we pursue issues of reparation. And even before I answer the question on evidentiary gaps or opportunities, is to just really echo what the rest have said about Africa having this relationship to the climate crisis that is really defined by a profound injustice, really. I mean, as I don't have to repeat this, but as we know, and it has been said, is that the continent contributes to a very small share of global gas emissions, global greenhouse gas emissions, which we know these are the emissions that have driven the warming of the planet since Industrial Revolution in the 1850s all the way till now, and we project that the warming is going to continue. And actually, we've committed to a lot of warming in our system. And that commitment means that even if we switch the taps now, it doesn't mean the impacts will stop. So we are really committed to the warming in our system, and all we can do now is to adapt, to support communities who are at the front line of the crisis, and for the for the historical and the new and the ongoing emitters to basically phase out the use of fossil fuels to continue to drive the economies and fuel consumerism. So really to say that we know that it's not just climate vulnerability that explains Africa's predicament, right? We know that the issue is it's structural. I think it's deeply structural. For centuries, the African continent has faced extractivism and economic entrapment. And these are not issues that are accidental. They didn't happen by mistake. They were really constructed or they were conceptualized during the colonial period. So, for example, organizations like the UN, for example, are formed in 1945. Remember, in 1945, there were none, or at least, I mean, very few, or at least none of African countries were independent. So really, they were not on the table during when the UN were formed, when the discussions were made. And we know that the conceptualization of the structural issues that continue to face our continent has been reproduced through a number of systems. For example, the global financial architecture, through the rules of international finance, trade, investment, taxation, name them. So really, for me, I think even being in this discussion today, to me, the thing is that Pan-Africanism is critical. And especially for us to really tackle the issues that are ahead of us, we really need to think about, for us to think about Africa's development and sovereignty, Pan-Africanism has to be the vehicle that takes us there, because we have the negotiating power to respond. We cannot effectively do things on our own, so we have to come together as a continent to tackle these issues. So Patrick, let me just go quickly to respond to your question. I won't take so much time. What has happened is that we've seen a lot of reinforcement of scientific evidence, litigation strategies, and social movements really advancing climate reparations or climate discussions or issues of losses and damages, or funds to respond to loss and damage. And I think this is really very important. I think these are the three groups or three fields that need to even come together more closely, work together, speak to each other, try to understand each other's fields and like speak a language that actually can make them work together. And on attribution science, we've seen now, if you look at the last like 10 years or so, there's a lot happening in our continent in terms of attribution studies, trying really to establish the link between greenhouse gas emissions, extreme events, and the observed harms from these events. So that is basically what attribution science is doing. And there's all sort of a causal chain, or understanding a causal chain all the way from the source, which is the emissions, to the losses and damages. And so we are seeing this science continue to help courts or advocates to engage more concretely in asking questions of causation and accountability. And then we see litigation strategies are evolving beyond sort of, I would call in quotes, sort of the traditional environmental claims to now towards human rights, thinking about climate debt swaps, thinking about even having strategies on reparative justice approaches. And really this continues to, so if you put this together, so evolvement of these strategies with the improvement of science and methodologies and understanding of the causal links really as the potential together to build these momentum, or to exert this political pressure or the moral pressure that is really necessary for legal developments and and for discussions on reparations. And we see civil society organizations, social movements being very critical, really, for this kind of creating this political and moral pressure. So if you combine the science, the understanding, the evidence from science, and then the legal strategies that continue to evolve, and then you integrate into these grassroots movements, indigenous groups, youth activists, global south coalitions, for example, and many other climate justice networks that have really helped to shape sort of the reparations from just a demand to more of mainstream justice discourse.
Thank you so much, Joyce. I have to admit, I'm hearing a desire from our panelists so far to also talk about this broader conversation around colonial reparations and how the climate crisis is tied to coloniality, which I'm very excited about. But of course, the hook of our webinar is to really focus on the opinion. So we'll try and balance this act. For now, actually, we had, I think, a lot of male speakers in the beginning. So let me pivot back to Joy. In the amicus submitted by SEAL to the African Court, you very strongly make this point that African states should pursue reparations from major emitters and corporations. Legally speaking, what are some of the strongest hooks for requiring states to act externally, to claim this, and not just domestically?
Thank you, Patrick. And thank you, Joyce, as well, because all of the panelists have been so inspiring so far. I think I want to point to what Joyce was mentioning about where the cumulative emissions are coming from, the source of it, right? And of course, when peoples in Africa are facing human rights harm, African states must give attention to obligations relating to access to justice, effective remedies, protection of rights. But the responsibility for climate-related harms and the corresponding duty to provide remedy and reparations, that lies principally with actors outside of Africa, major historical and contemporary GHG emitters. So in this context, the obligation of African states to ensure access to justice for affected populations and to protect their rights also includes, from a legal perspective, a duty to seek and to facilitate international assistance and cooperation under legal sources, including human rights treaty law, for example, the International Covenant on Economic, Social, and Cultural Rights, and their general comments. If you look at the International Law Commission's draft articles on the protection of persons in the events of disaster, we have these sources that give states kind of make clear this duty to seek and facilitate international assistance and cooperation. And often there is a need to make that presence more known at the table, as Joyce was saying, as global majority countries are stepping up. This is important. And this does not mean that the liability of those most responsible for climate harm, it's not a substitution, it operates alongside it. And we have with you, Patrick, because we wrote the reparations arguments together, we did argue that African states have a duty to vindicate their population's right to remedy by also pursuing reparations from historical polluters, including through multilateral arrangements. And the duty to ensure remedies includes taking all appropriate measures to secure reparations from responsible actors, whether that's through interstate claims or diplomatic means. And of course, such pathways can be very politically and legally difficult. Now, the ICJ in the construction of the wall in occupied Palestinian territory has affirmed that states must cooperate to bring unlawful situations to an end, including through collective efforts, and apply to climate change, where emissions by major polluters are harming the fundamental rights of African populations. This reinforces the necessity of international cooperation within global majority countries to end serious rights violations, to prevent and repair climate harm. So if you look at these, with the obligations to mobilize maximum available resources and to fulfill human rights, this may extend to taking reasonable steps to pursue reparations internationally, not merely as a political discretion, as a matter of political discretion, but as a logical implication of states' human rights obligations. And under human rights law, as we know, and I promise I'm wrapping, Patrick, the principles of equity, state responsibilities are differentiated. So states that have more capabilities, more resources are required to provide international assistance, including extraterritorially, and for the realization of human rights. African states, therefore, would be acting consistently with equity when they seek reparation from those most responsible for global emissions and who have the most resources, often from the fossil fuel industries that they have pursued. So to refrain from doing so would risk leaving their populations without access to the remedies to which they are entitled. And while interstate claims and diplomatic negotiations are pathways to secure remedy and reparations externally, states may also consider and cooperate towards the establishment of multilateral arrangements and funds to deliver climate reparations. And of course, given the historical injustice that we have spoken about, this can feel like yet another burden placed on those experiencing the greatest harms. It does not feel fair, and it isn't. But it is a potential legal pathway that, together with movement power, may help shift the needle. Because as Frederick Douglass has said, power concedes nothing without a demand. It never did, and it never will. So I'll stop here, Patrick.
Wow, that's a very strong quote. Thank you, Joy. Just to say, I mean, obviously you've outlined the sort of legal playing field, and I wonder politically, how feasible is it for states to seek, African states to seek reparations from the global north, if you will? Alfred, you've moved in the political spheres probably a lot more than many of us. So I'm keen to hear your perspective. How politically feasible is it, given that there's this loss and damage fund, given that now we have a United Nations General Assembly resolution on slavery? So I'm just keen to hear your assessment on the political feasibility thing.
Yeah, so thank you, Patrick. I have joked with my colleagues that, like, yeah, it's a very fierce and radical activist, but because of this work with the petition before the court and our engagement with states, right, encouraging them to submit observations, to be part of the petition process. Because as you know, there's something very unique about a petition before the African court. This petition is a people's driven petition. It's a petition that was submitted by civil society. And I think it's important to emphasize that. In the Inter-American Court, it was Colombia and Chile. In the ICJ, it was Vanuatu with recommendations from other states from the General Assembly. In the Law of the Sea Tribunal, it was Small Island State. Yes, there was civil society mobilization, campaigning around those processes here and there. But before the African Court, on the record, is civil society. And we are now trying to find a way now to get our governments to join this process. And we are making some progress. Governments are coming, they are doing this, and we can see the signs. So when you talk about how politically realistic this thing is for African state to advance the whole construct of reparation, here's what I would say. I will point you to some trends, some signs that we see coming out to make us to believe that, yes, there's some hope, there's some realism. And I'm sure we talk about a couple of that. The previous speakers have talked, the first two introductory speakers said about that. For example, the AU has officially declared 2026 to 2030 as a decade of reparation. That's a sign to show that there is some political buy into the whole concept of reparation around that. So you see that, and you can put that in your basket. And then, we've come, you just talked about that, and I'm sure someone mentioned that. The UN resolution that's sponsored by Ghana and others that talks about a permanent remembrance of the victims of the transatlantic slave trade and the cause for reparation. That the transatlantic slave trade was the gravest crime against humanity. and they're providing a moral and legal foundation for reparation discussions. So it reflects a growing international consensus on this issue. So we put that in the basket as a sign, right? But also, if you look across the globe, the whole construct of the operationalization of the loss and damage process, right? We'll see how that is going for. So we put that into the basket. And then we believe with this petition before the court and the guidance provided by the court, we can see that there's going to be some growing interest in litigation and arbitration to try to address this, increasing in African countries, given the data, given the attribution science, we'll find a way to address that. But I just want to make sure that even as realistic as we feel that this is, there are some challenges to this realism, right? As we see, and we are not impervious to that. So we know of the massive opposition that will come from major economies, especially from the West. We already see, US, UK, the EU countries in terms of how the whole issues around reparation. And then, we heard Joyce speaking about the whole issue of trying to establish causation. So yes, there's a causality problem, being able to establish clear, direct causal link between historical colonialism, industrial emission, and specific climate damages would be a problem. And then we're also seeing economic dependence. We see many African countries, despite the withdrawal of USAID, despite the withdrawal of US support, they're still in economic dependence on foreign direct investment, but overseas development aid, which in a way we know mitigate and limit the African countries or trying to engage in. So that's what the balance is. And we think moving beyond those processes, we think maybe if Africans can think more about, establishing clear financial and technical autonomy, building the ability to generate more evidence, like getting Joyce and others from the scientific team to build evidence for the process, having more structural economic reforms and more global solidarity among society could allow for us to figure out that this realistic, political process that we feel going in, we can ensure its sustainability. Thank you.
Thank you, Alfred. We actually have a question in the chat from one of our audience members, Emeka Ona, that I think is relevant to put to the whole panel here. They're asking, how can grassroots organizations and youth-led groups in Africa use the African Court's advisory opinion to advocate for climate reparations and stronger protection for communities most affected by climate change? Would you like to take that question? I think it kind of ties in with what you're trying to say. No?
Yeah, please. Do you want me to go?
Please do.
Oh, absolutely. In fact, one of the reasons why we brought this petition was basically what we saw had just the diminished or the limited amount of actions taken by Africa to address the climate crisis. I mean, let's be clear. If you look at just the data, right? I mean, and I reference specific data on the Sabin Center. I mean, there's less than 0.87% of the cases that have been brought to address broader climate change. But even if you're talking about reparation, it's 0.87%. If you put Africa in a global context, it's 8.5%. So you can see that we have not been able to spur really serious, whether advocacy or legal action to try to address those issues. And so we believe that grassroots organizations will have very important guidance from the court. And there are many ways to look at that. We feel that the opinion will first could be used by civil society to build a lot of campaigning, because they will have some very clear guidance, very clear standards to figure out, here's what the code is saying regarding reparation. Here are the specific actions that government could take. Here are the specific actions that civil society could take. Here are the specific actions that private sector could take. Here are the specific actions that media could take. Here are the specific actions that government could pursue. What do I mean by that? So, for example, grassroots group could build pressure even on civil society group to say, look, you got to pursue litigation on reparation. You got to make this a part of that process. They can encourage government to make sure that they incorporate this into their planning processes, into their program processes, in terms of addressing the climate processes year and year. They will allow that to even go into legal reforms to put laws in place to address the, so it's not just voluntary. They can start working with private actors to ensure that when they are building up their program portfolio, their investment portfolio, that it addresses the whole questions of mitigation and adaptation in your supply chains to find a way to reform all of them. So those can be really driven by grassroots groups to ensure these things are happening. Thank you.
Thank you, Alfred. I'm kind of looking at you and Chico because I feel you also have relevant experience in this regard. So to keep it with grassroots communities, based on your advocacy experience, what would you say are some of the biggest barriers that communities face in actually accessing remedies and accountability mechanisms?
Yeah, thank you very much for that. I think at a really basic level, it's just the lack of political goodwill. Yeah, we can bring, like the rest of the technicalities, really later, but at the most basic level, it is the lack of political goodwill, particularly from states and corporations who are still enjoying, the comfort that they're not ready to surrender over all those centuries of exploitation and subordination of many people and peoples on the continent. But really, there are many issues, and I think the list is super long, and anyone, in this call can have a bit to add to that. I think funding is an issue. Just looking, generally at the civil society ecosystem currently, the question of funding, I think, is one of the key issues. But also, if we may just look at the growing momentum on the question of reparatory justice on the continent, looking at slavery, looking at colonization, I think it will be very interesting to see how African countries deal with statute of limitations, particularly when it comes to land, because many of the climate issues that we are seeing on the continent, particularly when it comes to adaptation, are also land related. But then for many of land claims, the statute of limitations, particularly in former British colonies, is 12 years. So it will just be interesting to see how that is going to play out. But really also just within international law, when it comes to the test of full reparations under international law, be it restitution, compensation, or satisfaction, there's this test that there has to be a sufficiently direct and certain causal link, yeah, between the wrongful act and the injury that we are experiencing right now, which again can be really complex, particularly when we are looking at historical claims, taking into account the passation of power from former colonial powers to our current government. The British, for example, have a Kenyan Independence Act, like giving all the liabilities and all the responsibility to Kenya, the same with Uganda. And then beyond that, you can look at population growth, land degradation that has happened really after, and then the question of quantification when you try to subject it to what we have currently within our legal frameworks, it becomes also very, very complicated. And as I said, the list can really go on and on.
Thank you, Chico. We have a question from Mandy Mudarikwa in the chat, and I think it very ties in nicely. After the presentations, I'm left wondering what doctrinal and evidentiary shifts are necessary for courts to move from the fundamental recognition of the need for colonial reparations and the recognition of climate harm as a rights violation towards ordering reparative remedies grounded in historical and structural responsibility, and what such remedies would look like in practice. I think you've kind of gone in that direction a bit already. It's for the whole panel. I don't know who would like to answer, but how do we move away from just rhetoric, and what do these remedies then really look like on the ground?
I can go fast.
Please do.
Sorry, let me come back after a minute. I think there's a problem with my power. Just 1 second.
It's okay, we can hear you and see you. But would anybody like to respond in the meantime? I see Joy burning, or Alfred. Joy, come in.
Yeah, I can go very quickly, and then I'd love to hear what Joyce and Alfred said. In terms of doctrinal or evidentiary shifts, Mandy, I think that I think what we have right now is we have the legal basis. Sometimes courts are hesitant because they think going very much into determining what states have to do. They like to give some appreciation, margin of appreciation to states. But where remedies, like if we take lessons from human rights jurisprudence, powerful remedies come when the case is designed with those remedies at the heart of it. So right now we have seen very powerful remedies being argued for before the ICJ. So many African states came before the court and argued about the importance of debt justice as reparations. Many coastal countries that are losing their territories were asking as continued recognition of sovereignty as a remedy for the fact that their maritime baselines should continue to be stable as a reparatory measure. So when we start to see shifts in the jurisprudence is when we make sure that those arguments are coming up in concreto cases. And like I mentioned before, climate reparations, that this is due as a right is relatively nascent. So I think now we need to build in those types of structural remedies in the asks that we're taking before courts, and remedy and reparation litigation in climate is exploding. So now is the moment. And then absolutely to make sure that those move forward, we do need that evidence flexibilization piece of it. And we need access to justice and the procedural dimensions of reparations rights, which is very much part of the reparations framework, to be respected and taken up by courts. But I'll stop here.
Thank you,
Okay,
Joy. Go
so
ahead,
yes, I'll pick up from there. So I think I did reference this before, and I just wanted to go back to it to see exactly, what this will look like, what reparation will look like, right? And we've been actually trying to tease this out. And there's been a lot of troubleshooting, brainstorming about what that will look like. What realistically will African countries be able to do to see what reparation will look like. So for example, the whole question about, how do we, address the debt burden? Would that be it, right? To say, okay, African countries, would they now make a strong argument to say, look, to address reparation, we think, the debt burden is something we need to find a way to address. That would be like, could there be a shift, from loan to grants, something like that, to try to address those processes here and there. And I think also what is important, and we don't see a lot more about that, the focus on the traffic thing. For example, how would this be able to address the illicit flows from across the Africa, where billions and billions are just vanish, from the continent that could be used to really address development. We'll figure out what that will look like. And maybe also, for example, some of the issues around responsibility and ethics, because there's a lot of conversation about, well, African countries are corrupt, African governments are corrupt, there's so much corruption. But, let's be clear, who's doing this? Who's bringing the money out in the bag and giving it to governments? And exactly where the banks, which bank are they depositing this money in, right? All the corrupt money, the fruit of corruption is put somewhere. So if you are a bank and you're somewhere you're hosting that, who is more corrupt? If you're a company and you bring in back up money to give the African government, so what is the accountability around that? So I think these are things we talk about. And then also the issue about, I think, moving Africa more towards, like really having financial and technical autonomy. Joyce also talk about how do we build the evidence? How do we build the scientific data? How do we build the technical data to ensure that we have a data to rely on? So we don't have to start going abroad from outside. So how do we build that kind of capacity in Africa to be able to help us to be able to generate the evidence? Then I talked earlier about the structural economic reform that will allow for the current existing financial institutions. And one of the colleagues said that, when, in 1945, when the UN was set up, but also much more the Bretton Woods institutions, where they were set up to address the critical structural issues that Africa was facing. I'm not sure that is so we can find a way to reform that. And then what does it look like moving away from the rhetoric, right? For example, what the court would think will address. So, for example, we are hoping that something like this, there will be monetary compensation and restitution, a framework that the court could advance, that it will bring up a decision establishing multi-year enforceable plans for restitution and reparation. We hope that this is something that will actually come out of the court. But there's also there will be guarantee of non-repetition. Because it's not just trying to address this, because we see that even in the work that we've done across the continent, even when he's trying to stop, you think you're doing that. You don't want a situation where the polluter says that, well, I can pay you $5 and continue to pollute. How can we show guarantee that this is not going to be repeated? So there's binding commitment to change environmental and trade policies, such as enforcing fossil-free exploration by setting businesses and dismantling the trade barriers that allow for things like that to go on. And then also the whole question of recognition of corporate accountability, especially in regards to parent companies that try to set up the scheme and all layers of subsidiaries in a way that avoids the kind of being liability. So I can feel those sort of alignment going to try to find a way to address it. These are things I see could be the trend and the way to move beyond just rhetoric to a realistic process. Thank you.
So just to add a little bit on that, moving from rhetoric into practical solutions, I just wanted to use the example of, so I've listened to what Alfred and Joya said, and it's really summarized most of the comments that I wanted to make. But let me just use this one example that came into mind when they were putting their points across. And it's on climate finance, looking at it in terms of climate justice and reparations. So it's not just about saying, okay, we want funds for adaptation, for mitigation, and for addressing loss and damage, but really saying, how do we use evidence or use information or lived experience as Africans to really position the discussion on climate finance to climate justice and reparations? And it's you must do that. It must be hinged on a number of things. And one of them is on historical responsibility. So basically you're saying industrialized nations have accumulated wealth through centuries of fossil fuel driven growth, right? That has contributed disproportionately to global emissions. And therefore the crisis is not just about, it's not just an environmental problem, right? It's an historical imbalance in the global economic system. So basically, you have to tie your narratives and your legal arguments and the science together to enable to move away from this rhetoric to really saying, how can we concretely ask for reparations, right? So and you have to say that it's not about charity, it's not hate, it's not Africa is not trying to say, oh, we need help, we're vulnerable, we need this, but it really requires meaningful transfer of resources, right? And technology and in a policy space that can actually enable sort of structural transformation or like really decolonization of the structures. Just to give an example is using debt relief or debt cancellation as a very solid example to say that for all the years that industrialized nations have benefited and have built and have created this imbalance in the economic system, can we talk about reducing debts for countries in the global south who continue to actually dig into their pockets to respond to escalating disasters, right? So for most countries, they really are. I mean, we see this happening a lot across the African countries. There's flooding happening in South Africa, the eastern part of South Africa at the moment. There was a heat wave 2 weeks ago. There's been extreme flooding happening in parts of Kenya, Nairobi. We've seen Horn of Africa having these multi-year droughts. So we're seeing escalation of these disasters, of these climate extremes, which I've found a lot of African countries unaware. And it's not just that they're unaware, they now have to respond to a crisis that they didn't create. So basically, they have to take out a lot or reallocate a lot of finances or resources from their national budgets that are meant to support critical services like health, like education, like social services, now to respond to flooding and droughts and heat waves and stuff like that. So basically, it's to talk about what do we really mean about debt for climate swaps, for example, or cancellation of debts because of this crisis that has been created over time. So really concretely putting that. And the other things about technology transfer, there are a lot of people who talk about just transition or we need to move away from fossil fuels, which is a good thing, yes? Because we know from science that every ton of carbon dioxide emission in the atmosphere continues to escalate these impacts that we're talking about. Yes, so we know that, and we know that we should all be switching our taps. But I think there is the CBDR aspect there. There is that this is a common problem, but it's also a differentiated problem where there are parties or there are organizations or players that need to take a more proactive role and really a leading role in that matter. And so when we talk about transition, we are talking about how do countries in Africa, for example, transition in an equitable, just, and in a fair manner, in a way that, for example, for Nigeria, you're saying, of course, you're using your fossil fuel reserves to develop, to eradicate poverty, to help to provide electricity, to provide clean cooking. So these very basic essential services that these resources continue to help, or really helping these nations to get out to support them. So it's saying that if they are meant to transition, they need the technology. So for example, you wouldn't be saying we import, say, solar panels from the West, for example. And because what that means is that these countries will be entrapped in this sort of system where now they have to be importing. So it really takes us back, or it continues, it propagates or perpetuates the system that has put us where we are. So I think when we talk about reparations and remedies, we should really think about what are the solutions. So first of all, thinking about what is the evidence, what has happened over time, why are we where we are, how did we find ourselves here, and then who is responsible for this, and also what is our role in this, and how can we contribute to this discussion. And then in that we say what would reparations or remedies look like that actually can support a meaningful structural transformation for the African continent.
Amazing. Thank you, Dr. Joyce. And I like how you casually addressed the question by Petra Said around changing narratives. We have a lot of engagement in the chat, and I would like to just keep asking some of these questions to the panel. So we have a question by Arnold Bujuma Batunde. What can we in Africa do regarding climate justice, given the resistance from major polluters on the issue of reparations? What strategies are there? The COP tends to be a matter for big business instead of focusing on the communities that are most affected. What can be done? So this question of political position in a space that perhaps doesn't necessarily lend itself to talk about reparations. Who would like to take that one?
There's been a couple of conversations this week and last week. As you know, there was a big delegation from France to Kenya, right? And I see my colleague, I was smiling. Just having been kicked all of West Africa, right? I don't know, is this politically correct to say so? I'm seeing everyone putting their tongues out. And then, in these massive delegations, you have some of the worst polluters like Total, who are all going and trying to sign deals and the violent process here and there. And yeah, I was talking about just transition. But, some of the issues that colleagues have brought, the whole question of trying to decarbonize the continent, And folks are like, but how do you even talk about decarbonization, when Africa is not actually carbonized? So what are you talking about? And then the whole question of the transition. You say, okay, let's work on a transition that is just. But a transition that is just must also must address the whole construct and the structural deficit of energy poverty, right? Where those of us who have been privileged to go across the continent, especially traveling at night, we have scenarios of, traveling across Europe and the US and Canada and Australia at night versus traveling across Africa at night, and you see it. Maybe that's the reason why, years ago they say it's a dark continent, but you can definitely see what this is about. So these issues come up. So when they're like, okay, what should we do to try to hold state accountable to address it? How do we focus on the opposition? We have to be realistic to understand that these are the challenges we are facing. And as activists, I know because I'm involved in this conversation with government, with other actors, and they put that directly back into your face. How do you find a way to respond to those issues? And I remember, I think it was Joy and some more colleagues were having this conversation about, the amicus brief and the trend we would take. And like, well, we need to really hold our governments accountable, right? We understand the less than 2% contribution. We understand the vulnerability that the continent is, but we also understand the commitment to Paris. So holding the line is important. But if you are holding that line has to be in equity. It has to be just. It has to be a human right based process. So that Africa is coming. So that Africa is not saying as we are on our knees and we are begging. This is gift that the West is actually giving us a gift. And you see that in all this conversation that we have had, cups after cups after cups, someone talk about Africa negotiating positions. And you never see a shifting. No matter how you shout, how you yell, how you puff, we understand where the power line is, who holds the power. And those who hold the power, who are making decisions, who are the major emitters, and it almost looks like Africa is powerless to address this. And so hopefully, with the guidance from the court, if we have very clear guidance, and this guidance is able to unite the continent to say, look, now there are no distinctions. No one can come, like France can leave, can be kicked out of, West Africa and come down and then move back instead of into West Africa. Hopefully that court can provide those guidance to say this is not going to happen. You don't have to address this. Hopefully the whole issue about if I can decide that, okay, we actually will go, to address the thing. We Africans can bring a petition before the ICJ to say, look, historical emitters, you are responsible, want to address this. Africa collectively has a region can bring legal actions against those countries and try to find a way to address that. Africans can decide that regarding the debt, we make a decision that across the continent, we are never going to pay these colonial debts that first and foremost were not things that we decided you set it up and we got caught up inside. So Africa began that. So the court can speak clearly, specifically towards those issues. So in that way, that can address some of the oppositions that will come out because many governments are pushing back. It help us to push through. They can clearly say, look, well, Africa, you can now hold a line, you can address Paris, at the same time ensuring that how the continent can grow and develop and ensure that its kids will not sit by the fire hard and read and study can happen. So the kids in Africa will be the kids all across the globe will have the same opportunities to go to school, to study, and have the kind of infrastructure that will allow them to coexist and have a livable climate to live in. But you can't ask Africa huge obligation and responsibilities when the tools that they need, the support they need, the infrastructure they need is not available. So this conversation has to be balanced. To demand on Africa, but also make sure the resources are provided. And as we see, most of us know the whole conversation around loss and damage is very distant. We are not getting there. So yes, we talk these things, but let's be clear. So hopefully Maybe with the court and some clear legal guidance that will help us to address some of the opposition that will come out that is very, very balanced, that is not just saying, Africa must do this, you must do this, you must do this. And the infrastructure is not provided, the support is not
Mhm.
provided to allow Africa to succeed and survive, that it will always be behind and become a beggar. Thank you.
Thank you, Alfred. And just being mindful of the time, we have about 4 minutes left, and I see you, Joyce, and I will give you the closing words. But before that, we have one fairly procedural question, but it's an important one, and I think it's one that matters to a lot of the people in the room. In fact, it's come up several times. How it's from Jean Gachet, but also from Eugene. Basically, how can communities participate in oral intervention on this African Advisory Court opinion? And if there is no such process, then how should we collaborate to lobby for oral evidence? This will give voice to the deeply affected communities, the voiceless. Who would like to answer that? And then
Um,
Joyce.
so I will speak briefly towards that and Joyce will come because I'm involved in this conversation. So currently I will say that we have a number of, at least in each sub-region of Africa, we have at least one community-based organization that is actually collecting the voices and evidence of the climate implications and submitting that as an amicus briefing for the court. So we're doing that. But also what we are anticipating, and we are hoping this will happen, would be, for example, that we can organize sub-regional hearings. So it's not just in Arusha. We are hoping we can get a court to get out so that it can hear not just the submission from the voices, but hear directly from people what they are seeing. We hope to be able to do that. And just to also say is that, I mean, for those who are on this panel and for those who have come to be part of this process, it will say that what has happened before the court, and the court have said that at this last opening, the president said, never in the history of the African court have they seen a petition like this. There's more than 100 plus submissions. The court has not seen this before. It has not seen the level of enthusiasm and support for this process. So the court itself is overwhelmed just with the logistic, the scale of this. But also, I will tell you, I know you said the court has, the deadline has expired, but I will tell you there's demand for the court to open up because there are hundreds of other petitions that are pending to come before the court. So there's going to be more than 200 plus petitions coming. People are now asking the court, can you open up to allow us to submit? Especially from African organizations and from governments who are asking those questions. Thank you.
Thank you, Alfred. Over to you, Joyce.
No, I'm really glad to hear from Alfred to say that they are trying to speak to the court to open or to grant an extension for submissions. Because of what I know, so I think the 100 plus submissions, Alfred, are mainly from CSOs, right? But I mean, but I think still the participation of governments is low, and we think really that can improve.
We have
So
like 10 governments now. Sorry for interfering, but 10 governments plus have submitted observations.
Oh, that's good. That's good.
Yeah.
But we need at least half. 54 countries, we need at least
Exactly.
20. What? Okay, so anyway, I just wanted to, on a light note to respond to that because I thought it's important. But there's that first question that you asked, and I think that is one of the trickiest questions that is posed every time about the lack of political will to transition away. And it's as simple as being dependent on this system this economic system that has for the longest time heavily been hinged on fossil fuels. So we think that an alternative will be very difficult. We think that it will compromise sovereignty of countries. So think about big players, for example, the US, they think continuing to drill fossil fuels is the thing that will keep them up there, unfortunately. And so, it's in relation to the current regime, and we hope this can change. But basically, we see this lack of political will, which is quite unfortunate. And it's not just that. I think we see the rising of far rights across the planet as well, saying, sort of undermining science. And it's not like they don't understand the science. It's just that they think if they face the science, they will be able to make these difficult decisions, which to me are not difficult actually, but I think very necessary. So, and just because it's a very difficult question and there's no answer to that, because I mean, we will try different avenues. We have been part of negotiations under the UNFCCC. We are now using the avenue of the court. We are using civil society or like social movements to come together to bring political pressure and all that, and social pressure as well. But I mean, we try all this, but I don't think we have like an answer to say what needs to be done or how do we solve this problem. I think it's a big problem. We should continue pursuing these different avenues. But I just thought, to me, a role that the African continent can play. And that is why I talked about these sort of Pan-Africanism is critical, is that we could leverage on sort of our regional cooperation to overcome, say, barriers of so like really to position ourselves on the center of the table or the center of discussions to say we are the biggest source of critical minerals, for example, that are required for transition. I mean, if transition is happening, hopefully it's happening. And we are also, even if that is not the case, but we are also the source of major raw materials, and we are the market for a lot of finished products. And we have the youngest labor force, or the biggest sort of population of younger people. And so we can actually leverage on this sort of what we call the wealth of the continent to enable this transition, to enable this change in the political will. So we say, for example, the current system is not working for us. This system of continuing to burn fossil fuels that hasn't even worked for us, and I mean, it's been against us for the last 200 plus years of obsessive growth, consumerism, and yeah, in the global north that hasn't really benefited us. We could say that we stand to benefit from a change in that system. And how can we be a player in the change in that system? So we could come together and say, for you to access our resources, we could, so first we have this sort of regional cooperation where we come together, we pool resources, we coordinate our supply chains, we build integrated markets across the continent, and then we say, for you to trade with Africa, this is what it means. You will have to cancel the debt that has existed for many years because of colonialism, because of climate crisis, and because of all these, for you to actually work with us. So really positioning ourselves at the center and saying that we are part of a system that hasn't benefited us, but how can we be a player in changing the system? And the good thing is the outcome of that is that it changes, it's for the common good. So it's for everyone in this planet.
Thank you, Joyce. And I have to say, there's a lot of outpouring of support in the chat. You see the different hearts and clappings happening. But just to say a very warm thank you to all of you for this conversation. I personally would like to continue it. Unfortunately, we've hit time. Maybe we can look into a part 2 at some point. I know there are a lot of open questions from our audience. But just to say thank you all for joining this important and timely conversation. A big thank you to our speakers, a big hand of applause to our interpreters. Thank you to Ciel for providing French interpretation for this event. A big thank you to our partners, Ciel again, and the African Climate Platform, and of course the Global Climate Legal Defense and the Human Rights and Climate Change Working Group for making this webinar happen. Thank you all. I'm sure we'll speak soon, and stay in touch. Bye. This webinar is now closed.